It's unconstitutional. The Supreme Court has ruled that the current practice of security forces detaining men for extended periods under the state of public emergency is unlawful. The ruling now means that hundreds of mostly young men detained can take their matter to court and potentially be freed. Giovanni Dennis has the details of this landmark ruling.
July 5, 2016, Attorney General Marlene Malahou Fort.
To successfully tackle the murder problem, some of the fundamental rights and freedoms which we have guaranteed to our people may have to be abrogated, abridged, or infringed.
There was upheaval in the legal and human rights circles in the aftermath of that statement. Subsequently, the government passed the Emergency Powers Regulations of 2018. It gives the Minister of National Security power to sign a detention order that can see detainees locked up indefinitely when a state of emergency is declared. Today, those aspects of the regulation were successfully challenged in the Supreme Court.
The ruling today signifies that the Emergency Powers Act in its current form is unconstitutional, as well as the regulations and the detention orders that flows from that. The men who are detained basically are complaining about the conditions that they are detained under, especially those who are detained for extended periods.
So what exactly happened today? The Supreme Court ordered 5 men currently being detained under the states of public emergency to be freed. The men had asked the court to have their detentions declared unlawful and unconstitutional. Isaac Buchanan is one of 3 attorneys representing the men. John Clark is another.
All of these applicants were in court pursuant to detention orders issued by the minister. The minister is not a judge. He did not conduct a trial, but he issued detention orders which in 4 instances had 4 Jamaican citizens literally at St. Catherine Correctional Center, which they call the Tamarind Farm Correctional Center. And we of the view that no minister, no member of the executive should have the power to send persons to prison.
Section 33 of the regulation says, in part, if the minister is satisfied that someone has engaged in acts prejudicial to public safety, he may order the person detained. But Attorney Isaac Buchanan argues this is an overstep.
It is stepping on the jurisdiction of the court and breaching the doctrine of separations of powers, and that is what's significant where that is concerned.
And we asked the court sided with us to order the writ for these men to be released. And the court ultimately ordered the writ for the bodies to be brought before the court on Monday at 10 a.m. for the men to be released.
The 5 men had been detained under states of emergency in East Kingston, St. Andrew South, and Westmoreland. The attorneys argue the ruling has wider implications for others detained under orders signed by the Minister of National Security.
Every person detained under the state of public emergency is being detained under system, extrajudicial detention, which no minister has the power to do. Our rights cannot be suspended as a tool to fight crime, especially in the manner it is done without procedural safeguards.
Giovanni Dennis, TVJ News.